Good afternoon, everyone. I'd like to welcome you to the LSK Nairobi webinar. For this session, Josephine Oyembe, our council member-elect, will be moderating the session. So I'd like to welcome her to begin. Thank you.
So thank you, Gloria, and good afternoon, colleagues. Welcome for this afternoon's webinar. My name is Josephine Oyembe, council member-elect of the Nairobi branch office. Now, I'm really glad to host this webinar, and today we shall be discussing the recent devolution of the advocates training program, which was done last week as a result of the cabinet approval. And we are honored today to have various speakers who are quite experienced in terms of the ATP matters. And we also have in our presence today the chair-elect, that is Ms. Helen Namisi, who I'd also like to call upon to give her introductory remarks before we go to introducing our speakers of the day. So Ms. Helen, over to you.
Thank you, Josephine. Thank you very much. Ladies and gentlemen, good afternoon. I am very pleased and honored to welcome you to this webinar this afternoon. As you know, the Nairobi branch is concerned with practice and welfare matters for advocates practicing in Nairobi and Kiambu counties. And one of the ways that we do this is to look at legislation and or policies that affect or are likely to affect legal practice or the practice of law or the profession generally. And one of these is the Kenya School of Law Amendment Bill 2021 that was sort of shot into the limelight last week following the communique from the cabinet meeting. So today we are privileged and honored to have with us two presenters who are going to be taking us through this discussion. I am praying that it's going to be an interactive discussion. Please feel free to use the chat section to ask questions. I also recognize the presence of lecturers of the School of Law. I can see Mr. Samuel Maniki, I can see Anna Kwanuche, and I can see Fred Wakimani, Karibuni Sana, and I can see other practitioners. So I am hoping that we can have this discussion this afternoon to just get a perspective of the repercussions. What are the challenges or possibilities from this particular amendment with respect to the students and also the legal profession? So Dr. Muntari will be talking to us from the perspective of the school, while we will hear from, and we'll also hear from Senior Elisha Ongoya, who will be telling us from the professional perspective. I also expect that we shall be joined by Dr. Peter Kituku of the CLE, and hopefully we'll also be able to pick his brain on this so that we can better understand this particular provision. What does it mean? I have been corrected by my seniors that the topic is not devolution, but rather should be liberalization of the advocates training program. And so I stand corrected. Please proceed with the webinar, Mutatis Mutandis. And so with those few remarks, I ask you to sit back, relax, listen to this discussion. Please feel free to interact with the speakers using the chat section. And I wish us all fruitful deliberations. Asante sana, back to you, Josephine.
So thank you so much, Chair-elect, for those introductory remarks. And I'll just go straight ahead to introducing our speakers of the day. And as you have heard, the format of the presentation today, we just want to have an interactive forum where we'll be sharing the challenges and opportunities as a result of this liberalization of the ATP program. So I'll just go straight ahead to introducing the first speaker. We have with us Dr. Henry Kibbet Muntari, who is currently the director and the CEO of the Kenya School of Law. He's an advocate of the High Court of Kenya with 20 years practice experience and also experience in academia. He holds a PhD in international trade law from the University of Melbourne, as well as a master's from the University of Temple, that's Temple University and University of Melbourne. He also has a Bachelor of Laws degree from the University of Nairobi. In terms of experience, he served before at the Kenya Industrial Property Institute for a period of 3 years from 2011 to 2014. He's also taught as an adjunct lecturer at the Riara University, Strathmore University, the Catholic University of East Africa, and the Institute for Regional Integration and Development. And prior to that, he also served at Moi School of Law for a period of over 15 years. So he's also served as a board director at the Kekobo and the Anti-Counterfeit Authority, and has been the chairperson of the Copyright Tribunal. So he's also done some research, which is primarily on the fields of regional integration, international trade law, and intellectual property law. So since it's an interactive forum, we'll hear the remarks from our first speaker, and then afterwards I'll introduce the second speaker, and then we'll have the session to go by. So Dr. Henry, karibu sana.
Okay, good afternoon, everyone. I'm delighted to be here today for this webinar on a very topical issue. So thank you to Helen and the Nairobi branch of the LSK for organizing this at such short notice. I'm delighted to see almost 70 participants have joined in, maybe more will be coming, which to me indicates the level of interest that we have in this particular topic of legal education in the country. So I'm just going to restrict myself to a few remarks on the topic. I do not have any presentation prepared, and then I look forward to some discussion, because I believe that the issue of legal education is one that requires a very participatory approach in terms of determining what works best for Kenya. So I believe this particular topic was sparked by the press release last week about legal education and training, and approving a proposal to decentralize the provision of the advocates training program. Those are the words used in the press release. So as to address what it states are challenges occasioned by the large number of students undertaking the mandatory postgraduate program at the Kenya School of Law. So I'm sure most, if not everyone here, has had a relationship with the school, passing through it either recently or further back in the past. So you are aware, I do not need to go into what the mandate of the school is and what it is that we do, but rather just focus on this issue of decentralization or liberalization, as some refer to it. Now, first of all, I think it's important to note that what were approved last week were bills which have actually already been tabled before the National Assembly. So this is by no means a done deal, even though the cabinet support is there. So one of the bills, the Kenya School of Law Amendment Act, is just aimed at streamlining the admission requirements so that they are all found in one place, rather than as they are currently in the Kenya School of Law Act and in the legal education regulations, which has caused us all sorts of problems in terms of admitting applicants to the school. So if that particular bill is passed, then that would address the issue of who is qualified to join the school. The other bill, which for some reason was not actually specified or stated in that statement, the Legal Education Amendment Bill, is, I believe, the one that we are concerned with today, which is aimed at giving CLE a mandate to license other providers of the advocates training program. And one may start by asking, going by what the press statement asked, and also some of what I have read on media. In fact, in today's dailies, there's an article, I believe, in the People's Daily about this particular issue. And reading that article, there's some misinformation in it with regard to the role of the school vis-a-vis the role of the council, the fees that are paid, and my senior Professor Agenda, former colleague, is also cited at length in that article. And one of the issues that has been often talked about is whether there is overcrowding, too many students at the school as a rationale for liberalization or decentralization. This morning, I asked for some statistics from our academic services office about the enrollment here at the school over the past few years. And when I look at the data, in 2015, or let's start in 2014, the school had admitted 1,326 students, which jumped the next year, 2015, to 1,878. So that's over 500 jump in 1 year. Then the next year, 2016, it went all the way to 2,067, which is actually the peak, the most number of students that have ever been admitted at the school. 2017, it went down slightly to 2,048. Then 2018, there was a big drop down to 1,635, which was around the same for the 2019 group. 2020 and 2021, it went up slightly to 1,716. This year, we have enrolled 1,500 students. So that's a drop of 500 students from the peak of 2016. And it is likely that the levels will probably stay around 1,500, 1,600, or even lower in coming years. So one may ask, has the school been unable to cater for those numbers? And I'd venture to say no. Of course, those who have gone through in those years may have a different opinion, but that'll be something we can discuss later. What the school has done is come up with methods and measures to handle the large numbers. And as I said, now this year, the numbers have come down quite significantly. Now, the other point I can make is if this discussion of decentralization had arisen 3 years ago in 2019, before COVID, then there would probably have been, and I believe that's actually when some of these discussions first came up. There may have been some justification in asking, why should everyone be required to go to Nairobi to attend the ATP? Why can't there be branches, campuses in different places around the country? But 2020, March, COVID happens, lockdown, and a few months later, we start online classes so that through technology, our students were able to learn from wherever they were in the country. So that was a 2020 group who have just been admitted or are being admitted this year. 2021, the same thing, the entire academic year was done online. This year, we have resumed physical classes after the lockdowns were lifted and some of the strict measures were loosened. And from the 1,500, we have got maybe 800 online and 600 to 700 coming to class physically. And what is of interest to me is when we did a survey this week, of those who are studying online, about 45% are here in Nairobi, another 9% in Kiambu, another 9% in Kajiado, so just the outskirts of Nairobi. So that's probably over 60% Nairobi and around. Then the remainder are scattered all over the country. We even have at least 10 who are taking the ATP from outside the country. So to a great extent, the issue of access to the ATP by circumstance of COVID has been addressed. And we are now able to take in students and have them participate in the ATP from everyone. Then the other issue, because decentralization after the new constitution came into force, is one of the principles that the central government, the national government, is supposed to undertake in terms of making sure services are available countrywide. And in the school strategic plan, which we are currently in the final stages of developing, we are actually planning at least one, if not two, campuses outside Nairobi. The locations will be determined by a feasibility study, where we hope to be able to offer some of these services, some of our services, whether it's the ATP or the PTP. So the school is conscious of the need to decentralize services and is ready to do so given support. And I think this cabinet press statement shows that there is a recognition, which I hope will be supported by resources, to take services out to the country. But this must be done in a way that makes sure that it is sustainable, and we do not have a situation like the universities where after opening campuses left, right, and center, some of them have had to be closed because they are not sustainable. The question of liberalization, I would not want to go too deep into it, because at the end of the day, that is going to be the mandate of the council to undertake. But one of the issues that I hope will be considered is whether the other institutions that will be licensed will be independent institutions, or whether we are talking about the existing law schools, basically adding another year to their programs, which in my opinion may be a bit dangerous in light of the fact that ATP is a clinical program, whereas universities deal with academic issues. So if we go the university's law school way, are we going back again to what existed when you do your LLB and afterwards you just go and do pupillage before being admitted? Or will we be having an independent competitor to KSL that exists autonomously and just offers the ATP plus maybe other continuing professional programs? So that is something I think that we shall find out over the coming months, if indeed the proposals are adopted and passed. We know we are coming to an election period. Parliament is probably going to be going on permanent or being ending its sessions within the next month or two. I'm not sure if there'll be sufficient time for these bills to be passed and enacted, but that is a discussion. At that point, of course, everyone will be able to weigh in on the proposals. But I think I can probably stop there and say I'm ready to continue the discussion once we enter the Q&A. So thank you very much, Josephine, back to you.
Sorry for that. Thank you so much, Daktari, for the insightful presentation on the Advocates Training Program, the admissions, and the current status. So without further ado, we'd like to go to the next speaker. And before we do that, just a reminder to participants, please note that if you have any questions as we proceed, I'm so sorry for that, colleagues. I got disconnected, but just before the disconnection, I was just about to introduce the next speaker. So sorry for the disruption and thank you for your patience. So the next speaker that I'd like to introduce to us is a well-known face to us, and this is Senior Elisha Ongoya. He is actually a governance and democracy law expert, and he holds a master's in law and governance, among other qualifications. He is currently the dean at the Kabarak University. So before I introduce him to speak, I'd like to just remind us that if you have any questions as you follow up in the presentation, note that you post your questions on the chat session so that after we have the presentation from the senior, then we'll go over to the Q&A and we'll have the interactive session. So over to you, senior. Karibu sana.
Thank you, Josephine. I hope you can hear me. There was a moment I missed and I was wondering whether I had dropped out of the meeting.
I think it's me who dropped out.
Can you hear me, Josephine?
Yes, we can hear.
Okay.
Yes.
Thank you so much. Thank you so much for this wonderful conversation that we have assembled here to have as I consider a wonderful location for a number of reasons. One, I have one foot in legal practice, in active courtroom practice, and I have another foot in the legal academy where I share my thoughts and experiences with students as a way of building them for industry. And I strongly believe that from the changes, whether they are policy changes or statutory changes in the legal education sector, because no sooner, not sooner than later, those changes are going to catch up with us. The second bit is I'm happy that the branch chair changed the, and I prefer to look at it in the context of liberalization of the economy generally. I guess from around the mid-90s to now, there has been continued progress along the lines of liberalization. And I think subject to safety nets and social protection programs, liberalization has its well-defined advantages that we cannot run away from. And it looks like there may, and therefore the legal education sector will not possibly be immune from liberalization. We may but in the fullness of time, I think the legal education sector has to submit itself fully. I think for the benefit of our listeners, a proper on legal education reform must be understood in the historical context. And these reports, some of them predate era, and I just mentioned a few. I think justice, if there is source for legal education for students from Africa, because the chair of the police committee was Lord Dewan in England. And I guess this was, and therefore Britain was trying to find out how to, create some semblance of institutions or systems that they will live in their independent states. Then we have the Akilano Akiumi Committee report of 1994, popularly called the report of the task force on the status and management of the Kenya School of Law, way back in 1994. Then more recently, and I think what anchors the current reform that we are discussing here, is the Gidung Wigai Report Committee of 2005, officially called the report you see happening first in the year 2012 when the Kenya School of Law Act and the Legal Education Act of that year were enacted. And now with these proposals that got a nod from the cabinet the other day, but which, as my colleague Dr. Muntari has pointed out, have been in the offing for quite a while. That gives us the context in which this is happening. And looking broadly at the legal education sector in this country, apart from the establishment of processing people to be licensed to practice law, for the longest time in this region, of course, we depended on the University of Dar es Salaam to train for us lawyers within the framework of the broader East African community at that point in time. Then in 1970, of course, we had this
Senior, we seem to have lost you. Senior, we seem to have lost you. And again, your connection, we are suggesting if you could kindly switch off your video to see whether we can have a better connection in terms of hearing you. So Senior. Okay, as we wait for Senior Elisha Ongwaya to come back online because there seems to be a disconnection, I'm also informed that we have with us Dr. Emmanuel Kituku from the Council of Legal Education. So I'd like to maybe give him an opportunity to make any comments he might have as far as the liberalization of the advocates training program is concerned, and then we'll get back to Senior Ongoya. So Dr. Emmanuel Kituku, are you present?
Hello, can you hear me?
Yes, we can hear you.
Okay, yeah, thank you very much. And Josephine, for the invitation. And yes, I've listened to Dr. Muntari, as well as Elisha Ongoya, and it's good that Dr. Muntari has put the rationale behind the changes that are sought in Parliament in proper context, and also just to thank Ongoya for presenting also a better historical context to these changes. But just to add a little to what Ongoya said, we also had the legal sector reforms, legal education sector. The task force on legal sector reforms that was chaired by Senior Counsel Fred Ojiambo, that made various recommendations on reforms to the legal education, and those recommendations have also provided a basis for the changes that are now being sought in Parliament. Then, as the listeners here may know, the Council of Legal Education is a governmental regulatory body, which largely has two broad mandates. One mandate is to regulate legal education providers. And under this mandate, we license, supervise, and ensure quality assurance in provision of legal education at college, university, and the postgraduate level. The second broad mandate, which is derived from the Advocates Act, is to administer the examination that is for the Advocates Training Program, which is currently offered at the Kenya School of Law. So I guess I'm here to talk about our second mandate on the ATP program. So over the years, the ATP program has been offered by the Kenya School of Law, and therefore the changes before Parliament now seek to liberalize the provision of ATP. But I also wish to inform listeners here that also the Council of Legal Education has been pursuing a program of decentralizing its services. And therefore, this year, for the first time, we offered the Advocates Training Programs examinations in Nakuru at the Egerton University campus as part of decentralizing the provision of that examination. And in the wider scheme of things, we also intend not only to oversee the liberalization of the ATP, but also decentralizing. Why liberalization? Just to ensure that besides the Kenya School of Law, we have other legal education providers who can offer the ATP. Why decentralization? Also following the constitutional imperative of decentralizing services offered by national government agencies, would also want to see ATP offered in other parts of the country besides Nairobi. So then, just a few points on why decentralization and liberalization is important. One is to ensure better access to the ATP for lawyers across the country. But the second and most important is to ensure better quality of the provision of the ATP by the providers who will be accredited. As you all know, competition breeds a race towards improving services. So that is how we look at it. Secondly, as I said, we're also complying with the constitutional imperative of decentralizing our services. And thirdly, moderator, can you hear me?
Yes, we can hear you, Doc.
Okay.
We can hear you.
Okay. Is that Elisha struggling to speak?
Are you back? Senior Elisha, are you back? I think, Chair, may I request you to try and reach Senior Elisha offline?
Okay, so if just when you'll allow me to continue?
Yes, please continue.
Okay, yes. Then the other imperative for liberalizing and decentralizing is also to improve the learner's experience. I mean, having the ATP only offered in Nairobi will preclude people from enjoying what other parts of this country can offer in terms of learning experience. And then also, we have a mandate to promote legal education broadly. And one way of expanding our legal education sector, Dr. Muntari has provided statistics on how many students have been admitted to the ATP. And largely, he will agree with me that our ATP has primarily relied on the Kenyan market. But it's possible to grow our ATP brand within the region, the East African region, and in anticipation of further liberalization of practice in the region, then it would be good to have centers of excellence in provision of ATP besides the Kenya School of Law. So again, we should also look at this process of liberalization from that context. And the higher the quality we provide in our ATP program, the better the value proposition we would have in enticing citizens of other countries in this region to send their students to our universities and also to the ATP program. Now, so as from a regulator's point of view, what opportunities do we have to make liberalization and decentralization work? Number one, and just to emphasize a point that was raised here, we need, of course, to ensure that the process of accrediting the new legal education providers is justified by statistics, by data, by science. So we need to establish where the need is. And as I had said, we decentralized the administration of the ATP exam only this year. And over 100 students registered to sit the exam in Nakuru. And with very limited advertisements and with a very short period of time for getting the word out there. So that shows you there could be a demand and a market out there for taking the ATP outside Nairobi. Then the other imperative we also need to consider here as a regulator is who's going to provide the ATP. Of course, universities would stand a good chance because they already have the infrastructure and they already have the personnel. But we also need to consider other middle-level and vocational training institutions of higher education in this country, the likes of the Kenya Institute of Management, et cetera, et cetera. And the reason why we also need to pay attention to these institutions is because they will and they can mobilize and have a dedicated staff just to look at the ATP. The reason being universities may rely on the same lecturers who teach the law programs to teach the ATP, and therefore the problem that we're trying to cure here of enhancing standards, ensuring there are better lecturer to student ratios, that can be whittled down if, for instance, we basically say that this program can only be offered by university institutions. Then the other consideration from a regulator's point of view is also, yes, quality standards. We already have quality standards for provision of legal education in universities. So one thing that we need to do as a council, and very fast, is also to develop quality standards for provision of ATP by the legal education providers. That may require some legislative interventions, but that is something that can be done before the process of rolling out the new legal education providers is underway. And my last point, Chair, is I would also like to inform the listeners here that the Council of Legal Education is in the process of reviewing the curriculum of the ATP program. And liberalization also gives us a good opportunity to test this curriculum under different settings. I also wish to inform the listeners here that this year marks 10 years of the existence of the Legal Education Act. And therefore, these changes are coming at a good time to help us also visualize for the next 10 years, how would we want to see the legal education sector evolving? Of course, decentralization, liberalization will be a very critical elements of how this sector evolves from in the next 10 years. Of course, we've had a very good 10 years since 2012, but now the next 10 to 20 years should also mark a period of great expansion as well as commensurate development of legal education in this Kenya. Thank you very much.
Well, thank you so much, Dr. Kituku. And maybe as you concluded your remarks, do you have any additional remarks on any challenges and opportunities going forward in terms of these new developments? I know you've highlighted on some of the opportunities, but do you have anything to add and any challenges foreseeable?
Well, in terms of challenges, as I pointed out, there's that dilemma on who will provide the ATP. So that's an area we need to carefully consider as a regulator and come up with a criteria so that the process of selection of the legal education provider is not seen as an exercise to privilege or give undue advantage to any existing legal education provider. The other challenge, of course, is that with many legal education providers, there will be additional responsibilities on the council, and therefore we also need to make sure that we have requisite resources to enforce, monitor, supervise the implementation of the ATP across the board. As I said, there's an opportunity for growing and expanding our legal education sector by looking beyond our boundaries. With more ATP centers of excellence, I think we can be in a position to attract students from the other region. But with that, there's also a challenge in the sense that with the liberalization of practice in the region, currently advocates from other parts of the East African community can practice in Kenya, notwithstanding the fact that they've been trained outside Kenya. But the converse is not true. It's increasingly difficult for Kenyans to practice out there. So then, for us to attract students from the other countries, we need to demonstrate a very strong value proposition, because other citizens from the East African community can study in their respective countries, join the bar in their respective countries, and still be eligible to practice in Kenya. So for us to attract them to our country, we need also to start demonstrating that our legal education sector espouses the highest standards of training. And I see liberalization as well as decentralization driving us towards ensuring that we have the highest standards possible for training advocates in this region. And I think that's all I wish to say for now. Thanks.
So thank you so much, Dr. Kituku. I don't know whether we have Senior Ngoya. Are you there?
Yes, I'm back. I'm in session.
Okay, thank you. So I think we can even hear you clearly. So I think you can proceed from where you left. When you dropped out, when you dropped out, we just invited Dr. Kituku from CLE to also make some remarks as you log back in. So karibu sana, welcome back. You can pick from where you had stopped. Senior Ngoya. Senior Ngoya, are you there?
Thank you. Thank you. I've had the privilege also of listening to Dr. Kituku's thoughts, which of course are very enriching. But just can you hear me?
Yes, we can hear you, but your internet is still not very stable. You're breaking a bit.
Just confirm you can hear me, Josephine?
Yes, we can hear you. We can hear you.
Thank you. So I had the privilege of hearing Dr. Wambua make his thoughts, and that's a very enriching thoughts. My apologies for the technical hiccup that has happened. But I had observed that if you follow the recommendations made way back in the Muigai Committee, decentralization of the advocates training program and possibly liberalization. Because that report recommended, among other things, that the courses offered at the Kenya School of Law at the moment, which we call bar courses, should be taught in a clinical and practical manner to facilitate skills transfer. Now, if you engage in andragogy and pedagogy training, you realize that clinical training demands small numbers of trainees proportionate to the trainers. So that demand for clinical and practical teaching of necessity called for institutions that have smaller numbers of learners per unit trainer. Then number two, there was a recommendation that we should not prohibit universities from teaching some of the bar courses at the university, although the students should nevertheless be required to sit bar examination later on in their training. And finally, it was recommended that CLE may set up other service providers to train in the advocacy program. So you see, way back 17 years ago, a thinking towards liberalization, a thinking towards diversification. But more importantly, the Githu Muigai Committee also recommended that the Kenya School of Law may set up campuses in other parts of the country on a need basis. Of course, for the Kenya School of Law to do that, there is need for greater government investment in education. And if you look at global trends in the funding of higher education, not just in Kenya, in many other countries, I've studied even countries like Israel, you realize that there is a reducing funding for research and higher education by governments generally. And therefore, to think outside the box and to see how these objectives can be achieved without pushing so hard the agenda of government funding, because it's diminishing anyway, liberalization becomes inevitable so that you have private sector players or other service providers coming in to supplement that is which is being done by the core service provider, in our case, the Kenya School of Law. I see a number of opportunities in this move myself. One, I guess, is because I have worked with the private sector in the legal education service for a long time, and I've learned to see the opportunities in it. I believe that there's an increasing number of people seeking legal education in this country. I'm cognizant of the statistics given by the director of the Kenya School of Law of the fairly stable number of students enrolling in the CPD, in the ATP program at the Kenya School of Law. But that is one facet of the problem. I don't know about this, but maybe further research will show us how many students are stuck between the university and the Kenya School of Law for factors beyond their control, like school fees, among other things. That may also help to give the bigger picture, because I've not seen universities reporting diminished number of students enrolling in their respective programs. So we may need to do some further study on that. Then secondly, there's an opportunity in the increased number of service providers, both public and private. And we've seen this with the universities offering legal education. The numbers have grown by leaps and bounds in the last 15 to 20 years. The number of institutions licensed to offer legal education at that juncture is increasing. So those are service providers that we can tap into in this liberalization move. Then I think Dr. Wambua has mentioned this, that the regulator has matured. The CLA has been around for a long time, but as restructured in the year 2012, it has done 10 years. It has gone through the first wave of the storm when it was taken to court in the exercise of regulatory function. There were parliamentary assaults on it. And I think it has picked some experiences along that path that makes it even better prepared to manage this new phase or this increased phase of liberalization. Then I think tapping from the university education system, we can see a vibrant private sector that is willing to invest its capital in the education sector. We've seen universities like Kibbet University, where I work, Strathmore University, Nazarene University, Riara University, among other private universities that are now offering legal education. So that gives us a hint at a private sector that is willing to take the risk and invest in the education sector, this being part of it. Now, there's also an increased pool of professionals that are willing and competent to offer services in this liberalized sector. And you can see this in the number of reasons. But now other universities out there, Kisii University in Kisii town has set up a law school that is thriving. Moi University in Eldoret has set up a law school that is thriving. Egerton University in Njoro has set up a law school that is thriving. Kibbet University in Nakuru, thriving. Kisumu campus, those two cities. We've seen those institutions being established and growing. So it means that there's a pool of service providers out there who are willing to venture outside the capital, Nairobi, and render these services. And that's an opportunity that we need to tap into. Now, one of the things that the Kenya School of Law enjoyed by being in Nairobi, of course, is if you wanted to collaborate, for example, with the judiciary to get some judicial officers to come to the school and share their learning, their experience with the students, the ODPP, the AG, land registrars on conveyancing matters, they were all available here. But investment in services, you have these officials also available in the field. You have judicial officers out there in every corner of the country. You have ODPP officials in the counties, the AGs, officials, the land registrars, so that if those institutions out there wished also to tap into these experienced people, inviting them as guest lecturers to share their learnings with the students in the field, then it's possible. That's an opportunity that I see myself. And of course, something else, the proliferation of ICT now that offers an opportunity for the institutions that may take up this challenge and offer the course to also tap into the residual talent in Nairobi through virtual technology to reach their students. So I see a bit of an opportunity there. We are moving largely from a command economy, so and therefore services that are centrally provided by government to the exclusion of the private sector is something that is thinning out. And whatever we do, however long it takes, the offering of the ATP program is not going to remain unaffected forever. I know for a fact that there's an element of nostalgia of saying, I went to KSL in this year. But I guess nostalgia is something that we live with all the years. After a while, people will get used to a new normal, which will be acquiring bar programs in institutions other than the Kenya School of Law. Would move. I think if the CLE were to exercise its regulatory mandate in respect of it, as it has done with the universities, in the fullness of time, of course, we'll have teething problems when it starts, but in the fullness of time, we'll have a vibrant participation of other players in provision of the ATP program. Now, let me mention something about this debate we are having here. I think this debate and other conversations that I encourage must follow have come at an opportune time when the bills are being debated, when the legal framework to enable this liberalization is being thought through. So it's an opportune moment to set up a good structure, a functional structure that will present lesser teething problems as we move into full implementation. So I think kudos to the Nairobi branch of the Law Society for presenting this opportunity for the conversation to start. And I trust that other people like the main office of the Law Society of Kenya and we, the education service providers and the Council of Legal Education will take up cue and continue this kind of conversations so that when memoranda begin being presented to Parliament, as the structure is being fleshed out, we have informed memoranda tapping to enrich the resultant legal and regulatory instruments that would then midwife the liberalized provision of the ATP program. Back to you, Josephine, at the Secretariat.
Okay, so thank you so much, Senior Angoya, for that presentation, and it was quite wonderful. We'll just move straight on to the Q&A. So for people who haven't posted their questions, please feel free to post your questions, not unless we have anyone who would wish to talk. If you'd wish to be given a chance on the floor, you can also raise a hand and then we'll see you and give you a chance. Now, we have one question that's from Isaac Kuloba, who is requesting for a discussion on the possible negative impact of the liberalization and mitigation they have. So I'd call upon you, Senior Angoya, as well as Dr. Muntari, if you could comment on that.
Can I go first?
Yes.
Okay, I think that's a very important point to make, that liberalization is not always positive. And one example I can take, I believe, since all of us or most of us here have gone through the Kenyan legal system, when the parallel programs were introduced, it started off quite small, and then they really took off and grew exponentially. Moi University, where I was at that time, became the largest law school. It actually overtook Nairobi University in terms of numbers. And even though the reputation of Moi University in the early years was very high, as the numbers grew, issues of quality arose to the point where a few years back, the accreditation was withdrawn by CLE. I think that's a matter of public knowledge, which we can all refer to. So that is one of the dangers of liberalization. If quality standards are not maintained, then there's a risk that you achieve the negative, the opposite of what you wanted to achieve. Something else I have also observed, again, drawing from my long experience in academia, is, and here there's a difference between public and private universities. There can be a bigger pressure in private universities to get people through the system, to have good numbers of passing and so forth, whereas the quality is, again, not being checked much. And this is something that at the school, now talking about the current situation, whatever problems that have been encountered in the 16 years, the 844 system of education, by the time someone is getting to the ATP for the final year, if that person is unable to communicate properly, whether in writing or orally, it is asking too much for the school in 1 year to rectify those failings. And that is something that I personally have observed a lot of times, where you struggle to make sense of what someone is writing or submitting. So there's a bigger problem here to do with the education system in the country that needs to be looked at, but which probably is not within our specific mandate. Then I also want to respond or to comment on one point that Senior Ngoya made about funding by governments for higher education. I do not think it is completely accurate to say that globally there is a trend towards reduced funding. I think that is probably an aspect of a particular type of government, which one does not have to take to be a prophecy or a situation that cannot be reversed. We know that there are countries in this world where higher education is fully financed by the government, where people are even given scholarships and stipends. That used to be the situation here at the school in the early days. So it is not, or we should not be saying that because government has reduced funding, we should not agitate or lobby for more funding. The same way it would be with the health sector, for instance. If the government is reducing funding for public hospitals, we do not say we shall go to private hospitals, or private hospitals can fill the gap. We can demand that the government steps up its role and provides adequate funding, because education is a public good. And I think that as the legal sector and the people who train people who will be in the judiciary, which is one of the branches of government, it is in the interests of government to actually provide sufficient funding, so that if decentralization and taking services to different counties is the goal, then we need to ask the government to actually to step in and do that to a greater extent. That's the comments I'd wish to make for now. Thank you.
Okay, so thank you, Daktari, for that comment. I wish to invite Senior Ngoya to also make his remarks on the first question that was posed, which was on the possible negative impact of liberalization and mitigation measures. So I can see Flavian Mulama, who's asking about the effects on the quality of training that will be offered. So I believe that has also been addressed, but Senior Ngoya, you could also maybe add on that as well. Karibu, Senior. Gloria, are you able to unmute Senior Ngoya? I've seen he's made a comment on the chat. Please unmute him. Gloria.
Yeah, thank you. I'm not unmuted. Thank you so much. So I think Isaac raised an important question. And the only challenge that is legitimate to me is quality control. The only challenge that is legitimate is quality control. We must all be jealous in guarding quality, because we cannot churn out numbers that are unqualitative. That will definitely facilitate the death of the profession rather than growing it, which I understand is the dominant objective of this move of liberalization, is to give more opportunity for growth of the profession. How do we deal with that? I understand my colleague Dr. Muntari's concern that with the proliferation of Module 2 programs and even the emergence of private universities has been said to have, to an extent, compromised quality standards because of an assumption that privately sponsored students and private programs come in with a business motive of trying to handle the customer as opposed to the student with a kid's glove of sorts. So that is something that we must flag out from the very outset and deal with decisively. Now, the advantage we have is that the regulator remains the same regulator. That's the Council of Legal Education. I work in a private university which is regulated by CLE. And I know CLE, for example, has been very particular about what we call the student-lecturer ratio. That if you have to offer a service, if you have to get our license, then you must tell us, number one, what is your student-lecturer ratio? Number two, you must tell us what is your student-book ratio. Number three, you must be able to show us physical facilities, your ability to mount the program itself. And those to me are quality assurance measures. CLE has even gone further to ask, tell us what are your terms of engagement of your staff, so that we know that you have motivated staff who are willing to commit to the cause, so that in the assumption that if we comply with this quality standards, then the issue of quality will be redressed. At the second level, the examination and assessment process for ATP, as I perceive it, will remain centralized, and CLE will remain the examining body. So whether you go to the Kenya School of Law, where you presumably you'll be subject to more bare knuckle training, or you go to the decentralized, the liberalized units, where there may be a temptation for people to have a business motive, you must remember that you're going to face the same assessor and the same examiner, which is CLE. And therefore, that will disincentivize. It will disincentivize the treating of the trainees with a kid's gloves. Just to draw some parallels with the rest of the education in terms of primary schooling and secondary schooling, you can go to a private school or to a government school, whatever it takes. But at the end of it all, you have to sit and pass the Kenya National Examination Council examination before you proceed to the next dignified level. So I think those are mitigating factors which, if well implemented, if all the role players understand their role, then they should be able to be dealt with. Of course, there will always be challenges at every point in time. Those challenges should be able to be redressable as and when they arise. Back to you, Josephine.
Okay, thank you, Senior. So we go to the next question, which is from Major Masibo, who is asking that what would be recommended with respect to harmonization of the ATP and the regulating authority, that is that's CLE and KSL. So he notes that it seems that there's a disconnect, especially when it comes to examination setting. So I don't know whether Daktari would want to make any comment on that. Just
there are two of us. You mean Wambua?
Oh, sorry. Actually, both of you would make a comment.
Okay, let me go first. Yeah. Well, there has been a problem in how the ATP has been offered over the years. Yeah? And it is not just a disconnect between the CLE as the setter and administrator of the exam and KSL as the teaching entity. But I think the fundamental problem has also been with the curriculum of the ATP. The last time we had content curriculum, I think was before the year 2009. And since then, we've offered ATP based on the course outlines and syllabuses prepared at KSL. But now we have we as CLE, we're in the process of developing a curriculum, a comprehensive curriculum that looks at all the recommendations that have been made in the past reports by various task forces that have looked at legal education. And our ambition is to have a curriculum that will help us produce practice-ready lawyers for the 21st century. And central to that curriculum is having a program, an ATP that looks at imparting skills to the lawyers who enroll for the program. We believe that much of the theoretical development of our students is done at the universities, and therefore the ATP program should merely impart skills that will enable the graduates to practice effectively and efficiently in our courts of law. So with the new curriculum, therefore, we also need to look at what kind of examinations will be administered. Already, some of the feedback we are getting, for instance, from our stakeholders is that the new curriculum should do away with oral examinations and instead focus more on the projects as well as moot courts and other practicals that are necessary to bring out the practical dimensions of the envisaged curriculum. Then also, the process of setting our exams has been undergoing changes in the last 2 years. We've had now to sit down with those who teach, those who practice, and those who are in the academia, just to see what should be the substance of the questions that will test our ATP students. And for the first time in this, the exam that we offered in April, the substance of the questions there were informed by the recommendations that were made out of the sitting that we had with the teachers, those in practice, as well as those in academia. And I believe going forward, our examinations will equally be enriched. But then also, the mandate of administering exams is something that we need to continuously improve. As Elisha Ngoya has pointed out, having the exam offered by CLE is an equalizing factor. If we go the liberalization and decentralization route, because no matter where you'll be taught, you will all sit the same exam. You will all be required to petition to become advocates based on compliance certificate issued by CLE, not the respective schools. But then allow me to just go back to the initial question that had been asked regarding risks or challenges that we may face as we liberalize and as we decentralize. CLE, as I said, one of our mandates is regulating legal education providers, certificate programs, diploma programs, degree programs, and postgraduate programs. Now, that mandate, as you all may know, has experienced challenges in the last 1 year or so, after the High Court decreed that the Commission of University of Education has the primary mandate to regulate university education. And what many actors, including the Commission, have interpreted that decision to mean is that professional regulators like CLE no longer have any business to do with regulating university education. Even though the matter is still before courts, if the sector players take that narrow interpretation that we don't have a role to play in the regulation of university education, then the nightmare that Dr. Muntari brought out is likely to revisit us, that universities may lower standards in terms of having more numbers, instead of in terms of also reducing on teaching personnel, in terms of reducing investment in infrastructure or facilities in universities. And the upshot is that the quality of training in universities is likely to diminish. And if it diminishes, it doesn't matter who will offer the ATP, the outcomes will be the same. We're likely to have higher failure rates, and those who will squeak through the ATP examinations will not be of the highest quality that our profession deserves. So there is need for sector players also to start looking at the ongoing court case with keen interest, because this will have great implication on the quality of the ATP and eventually the quality of the practitioners in our profession. Thank you.
Yes, so thank you for that. Dr. Muntari, do you have any comments to make on that question?
I think I'll just say that in terms of exam setting, we are continuing to work closely with CLE to share course outlines and what we teach. And recently there was even a retreat where we went jointly to see how to improve that process. So I think those concerns have been heard previously, and they are definitely being addressed. But yeah, our interest is always to make sure we give the best training possible, so that it's not just a matter of passing exams, because passing an exams is an event of one day, but making sure that the entire training imparts the necessary skills to to our students. Thank you.
Okay, thank you for that. We go to the next question, which is there a danger of silent discrimination based on schools of law that one attended? We already have an underground situation where employers ask, please give me a pupil or advocate, but only who went to this and this university. So I think I'll throw this question to Senior Ongoya. Senior Ongoya. Senior Ongoya, are you online? If it's not there, Dr. Muntari, I'd request you to respond to that one.
Thank you. I think that's an issue ever since the LLB program moved out of Nairobi University to Moi and then all the others. Over time, certain impressions get formed about which are the better universities. And it's inevitable because there will be some differences in the quality of the graduates. And if we get other law schools, then no doubt that would also start appearing. But also just to talk about the issue of quality and decentralization. One advantage, I think, of having, if it was the Kenya School of Law to open other campuses, would be the fact that because they are all related and closely linked, the quality would be the same. Of course, someone would argue that if your quality is bad, then that means that you're just decentralizing poor quality. But I think I have enough faith that we have good quality, a good quality program at the school. And if it was an issue of decentralizing through establishing campuses, we'd be able to maintain that quality. Thank you.
Okay, thank you for that. I've actually noted that Senior Ongoya had been muted. So Gloria, are you able to assist? Please unmute Senior Ongoya so that he can make a comment.
Thank you. Thank you.
Fantastic. Go on.
Thank you. Thank you. Just I think I can hear me now.
Yes, we can hear you.
Thank you. Thank you. Now, the question about the industry doing what the interlocutor calls discriminating is a very strange thing in the relationship between training and industry. And I say this because it's actually not a very bad thing if you look at it in terms of its long-term effect. It's actually one of the ways through which industry cures part of the challenges that Dr. Muntari had alluded to. Now, university is just that. An institution is just that. And you come in with a piece of paper called a certificate. The value of that piece of paper is the recognition for that piece of paper. That's the value that piece of paper carries. Is how does industry value that piece of paper? So that the concern by industry about graduates from a particular important facilitator for the institutions upping their game so that industry plays along with them, so that when you generate products, industry graduates. So we cannot rely on CLE alone to guarantee quality. We must also rely on others, the market. We are told all the time that when you get into liberalization, there's something called the market with an unseen hand that then controls, demand and supply. And if market uses proper fundamentals of productivity, then we will actually see institutions going out of their way to generate best quality products. Because if I am offering a course as Ongoya and Wambola advocates, we are offering an ATP program. And every lawyer out there, every government agency out there says we don't want to employ anyone from that firm, then I have no business in the industry. So it means I must up my game so that my graduates are received by industry, so that they become my #1 advertisers and marketers. That if you go to this institution here, the market receives you well. As a consequence, people will be competing now to meet the quality demands of market, as opposed to just passing students for the sake of it. The challenge raised by Dr. Muntari was valid. That if you allow people to get more students because you are perceived to be putting on kids' gloves for them, to be, so to speak, passing them, there's another checkmate called market, called industry, that may truncate you. People will say graduates of that institution are not marketable. And therefore, I see this as a positive. Of course, there may be extremes of discrimination that may require interventions, but when properly used, I think this is what we may call positive discrimination, where the market shuns institutions that have no product of institutions that have no regard for quality, while falling over each other to go for products of institutions that are reputed for quality. Back to you, Josephine.
Okay, thank you. Thank you for that. So we'll proceed to the next question, which is from Oliver Agina, who is asking that we know the private institutions tend to charge higher for their services. So how will the CLE regulate fees chargeable to students by private players in this liberalization and decentralization process, so as to ensure that the ATP is still affordable to the majority of students? This is so that we don't end up with the liberalization of the ATP, yet the Kenya School of Law is still weighed down by student numbers due to their affordable fee. So this one, want Dr. Kituku, are you able to comment on that?
Oh, yeah, sure I am. I hope I'm unmuted.
Yes, you are unmuted. We can hear you.
Okay, yes. Well, CLE may not have the power to regulate the fees that are to be charged by these institutions, but what we can regulate is the level of investment that these institutions can make towards offering and delivering the ATP in their respective campuses. That's something that we can do. And that could also have an impact on how much how much fees can be charged at the respective institutions. The other thing we can do, and we are currently doing with universities, is regulating, for instance, the number of the minimum number of personnel they can have for purposes of teaching, but also supportive functions like library, etc., etc. We can also regulate on the facilities that the institutions are supposed to establish, moot courts, yeah, the size of classrooms, where the campus is located. Those are things that we can, and those may impact on the fees to be charged. So what we are concerned with mostly is the quality of the education that is to be offered by the legal education providers. As for the chargeable fees, I think for government institutions or for public universities, their respective university policies will determine that. For private sector, it's the market. But I see the market playing a larger role in influencing the choices of the consumers of the ATP. I see the market playing a larger role. So our work is to determine, no matter how much is charged for fees, is it being invested sufficiently to foster the highest standards possible for provision of legal education at that level? Over to you, Josephine.
Okay, thank you for that. So we proceed to the next question. So there's a question on 40% of exams, that is orals and the project, is administered by the trainer, which is KSL, on behalf of CLE. When different institutions undertake ATP, how will the award of the 40% be standardized? So that the question is, are we likely to see discrepancies between this portion of exams, because each institutions will now have the discretion on awarding marks under this portion? So the question is, will CLE take over the 40% for standardization purposes? I think for this one, the two Daktaris, either of you can answer that question.
Okay, I could go first, then Dr. Muntari. Yes, the administration of ATP is a mandate of CLE, but we've entered into an agency agreement with the Kenya School of Law to administer the orals and projects examinations on our behalf, and also to supervise pupillage, because pupillage is also regarded as a requirement for passing the ATP. So the KSL has administered that on our behalf. So, but the thinking, the current thinking behind also the new curriculum is that the council should take over the administration of the entire exam, yeah, including also supervision of pupillage. And that should sit well with the intentions of liberalizing and decentralizing the ATP. By having the council as the regulator in charge of all aspects of examination, that would be an equalizing factor. And the risk of discrimination, as somebody said, could be lowered if you have a neutral institution administering this exam. But that doesn't mean that Kenya School of Law has not been doing a good job in administering those examinations on our behalf. We are grateful for what they've done, and especially because CLE was a young institution, we were still grappling with our rather expansive mandate. And now that we've matured as an institution, then I think time is also right for us to increase the number of responsibilities that we need to take as the gatekeeper of the legal profession in this country. Over to you.
Okay, thank you for that. Dr. Muntari, do you have any comments?
No, I think on this one, I will defer to Dr. Kituko, as examinations is really a CLE function.
Okay, so thank you. We'll just proceed to the last question. So the last question is from Damari Ayuku, who is asking, would it not be better to decentralize KSL, or rather liberalize KSL for students to have clinical experience? So these I'd wish to request Celia Ongoya to respond to this. Gloria,
Well,
mute.
Thank you. Can I be heard now?
Yes, you can be heard.
Thank you. Now, I don't think the debate is mutually exclusive. I don't think that the call for liberalization, other service providers in addition to KSL to offer the bar program training to the decentralized, currently structured, establishes campuses in other parts of the country. I think they can go hand in hand, but that is subject, of course, to the school's own financial resources, physical facilities, and human resource capabilities to be able to do that. So I don't think personally approach this debate looking at either or liberalizing the ATV program. I think they can go simultaneously, so that if you have an institution like Masinde Muliro University in Kakamega or Kisii University in Kisii, proposing to start an advocacy training program as part of their program, subject, of course, to meeting the regulatory quality assurance requirements, that does not stop the Kenya School of Law from establishing a campus to also move. Josephine, back to you.
Okay, thank you. Thank you for that. Even though I believe we lost you as you are concluding. I don't know. I think we lost you at
I just observed that there's no mutual exclusivity in the proposals. We can have the Kenya School of Law decentralizing, having campuses all over the country, subject to financial, physical, and human resource, and at the same time, other service providers supplying the same service of training in the ATP program.
Okay, thank you for that. Yes, thank you. I know I had noted that was the last question, but I hadn't seen last question from Elvis. Then we proceed to maybe the final submissions or final remarks. So there's Elvis who is asking for a comment on the harmonization admission requirements to the advocates training program in light of the amendments, so as to accommodate students who initially qualified for admission to the undergraduate law training program by dint of virtual progression, that is, started with a diploma in law, then subsequently to LLB. In terms of interpretation of which legal regime must KSL refine their prescription of admission requirements. So Dr. Muntari, are you able to kindly comment on that question? And I hope
yes, I can comment, and I'll be brief because this is one of the issues that we spend a lot of time on. There is currently a conflict, as we interpret it, between the KSL Act and the provisions for progression under the legal education regulations. As I mentioned at the beginning, it is our hope that if the Kenya School of Law Amendment Bill is passed and enacted into law, that conflict will be resolved for once and for all, and will address the issue that the question raises. We also have, as a result of all the court cases, a case before the Court of Appeal currently to resolve a conflict in the High Court between the interpretations of the second schedule. We are hoping to get a judgment in the next month or so two, subject to the court's calendar, of course. And yeah, but that's one thing that really gives us a headache, and we hope to have either a judicial resolution or a statutory resolution through Parliament to that issue. Thank you.
Okay, well, thank you. I know we are really way past our time. So at this juncture, I just want to close the Q&A session. For any questions that are unanswered, we'll try and answer them offline. And I'd like to just call upon our speakers for the day to make their concluding remarks. So we can start with you, Dr. Muntari, followed by Dr. Kituku, and then we finish by by Senior Ongoya.
Okay, thank you very much. I think in closing, I'll just say that as a school, we are committed to being a center of excellence in professional legal training. We are welcome to any suggestions as to how we can improve the services we offer. In our next strategic plan, we are planning to decentralize, subject to the availability of resources. But we are also happy at the moment that with online classes, we are actually able to address the issue of accessibility. As I mentioned at the beginning, we have students following our ATP classes from all around the country and out of the country. So access is an issue that we have been concerned about, and I think we are doing a good job and hope to continue improving in that regard. But thank you to everyone who has stayed till the end. I can see we still have over 100 participants, 1.5 hours in. So I appreciate, and thank you also to Helen for having organized this webinar. Thank you.
So, Dr. Kituku?
Yes, sir. Thank you, the Nairobi branch of LSK, for organizing this important discussion. I think we should see this as part of public participation towards the enactment of those two legislative proposals. And our view as the regulator is that these are good opportunity for us to strengthen the legal education sector, both in terms of access to legal education, but also in terms of quality of the legal education provided at the ATP level. So let's engage with the legislative process and ensure that the outcomes we envisage will be realized through our parliament. And we wish to give the commitment to the sector that if Parliament decides or agrees with our long-term vision of decentralizing and liberalizing, then we shall ensure that we have the adequate regulatory framework to make both liberalization and decentralization a success for this country and for our legal profession. Thank you very much.
Okay. Senior Ongoya.
Thank you. Thank you, Josephine. Yes, one thing, the Kenya School of Law to any advocate in this country is actually a heritage. I think every lawyer has an opportunity to speak about their experience at the Kenya School of Law. And I guess this has been so from 1963 to date. That's a whole 60 years of excellent service to humanity. And therefore, we must remain eternally grateful to the Kenya School of Law. It has never collapsed even once, even as other organizations like the Kenya Railway were collapsing. The Kenya School of Law remained and has remained up to now. So we must give credit to it. It's a major heritage to the legal profession. I have had the privilege of working at the Kenya School of Law myself between the year 2008 and early in the year 2015, when I went to serve as a dean at Kibbet University Law School. I still offer guest lectures at the Kenya School of Law up to date, and I can authoritatively state that the Kenya School of Law has very good quality standards, including its standard operating procedures and quality assurance measures. I have no doubt in my mind that when CLE begins licensing other service providers, there will be a rider that each one of them must go to the Kenya School of Law for some form of benchmarking on how they can structure their program to be sustainable. After all, as I've said, the KSL has been sustainable for the last 60 years, and it therefore has vital lessons to be able to offer. Like my other colleagues have said, Dr. Muntari and Dr. Mbua have said, this is an integral part of public participation. I want to encourage the lawyers on this platform to remember this is about them. When this debate leaves this platform and goes out there before Parliament and public views are being called, public memoranda are being called, let the lawyers on this platform understand that it is for them. It is not for the engineers, for the teachers, for the doctors, grave diggers, and street sweepers to make a contribution to. It is primarily their domain as lawyers to come and make meaningful contributions on how this process can be handled better so that it does not end up aborting as an experiment by the Council of Legal Education and by the Kenyan legal education sector. Thank you so much for the audience, and God bless you.
Okay, so thank you so much to the speakers. As for me, and in terms of, okay, before I proceed, I don't know, Chair-elect, I don't know whether you're still present and whether you'd want to make any final remarks. Helen? Okay, so for me, I just want to also thank you, colleagues, for being patient with us despite the technical hitches we've had here and there. And also you've been patient in terms of time. And you've also actively participated in the webinar. So thank you so much. And I'd also urge us, just keep checking the Nairobi branch website. You'll see the events that we have and any other webinars and functions and activities so that you can be able to participate. So at this juncture, I'd like to close this webinar and wish you all a great afternoon. So see you in the next activity or webinar. Have a great afternoon.